Very good. Well, today we're going to talk about some very interesting things happening on a national front. And that's why we pulled in Casey, our legal eagle, our VP, our legal counsel. She always has very, very interesting stories to tell. So Casey, tell us what's going on with the Anywhere lawsuit settlement.
All right. Well, thank you. And thank you, everybody. It's great to be here. Great to see everybody. I wish I could see you. I guess great for you to see me this morning. So first of all, I want to start off. I saw a couple comment, happy Friday the 13th. And again, that's probably why Sarah started with her superstitions. It's usually a spooky day, but this is not a spooky topic. So I know it's been a big discussion in the industry and the impact that it may have, but I want to talk through it and see how it impacts us specifically. So to kick it off, I want to start by giving a summary of the lawsuits. There's two lawsuits that we're concerned about here, generally known as the Burnett and Morrill cases, or the Sitzer-Burnett and the Morrill cases. And if I'm mispronouncing those, I apologize. Sometimes names are harder to say. So one of the first cases, the Morrill case, this was brought by a seller, Christopher Morrill, and was certified as a class action this past March. This one is encompasses sellers from across the country. So this does have a national impact. This case is expected to go to trial next year, sometime early next year. The other case we're dealing with is the Sitzer-Burnett case. This is also a class action lawsuit. This one, probably for our friends in the Overland Park area, are most familiar with it. It is limited to home sellers in Missouri, and that trial is scheduled to start Monday. So there's been a lot of hype about this case because the outcome of this trial will likely impact the Morrill case as it goes forward in 2024. So Monday is when this trial starts. I wouldn't be surprised if we see more action on that today because most cases settle the day before the day of trial. So I'm sure they're in deep discussions about final trial setting. They're doing jury selection today. They may be talking settlement. The implications of these cases, and the amount of damages that they're facing are significant. So summary of the cases, we've got home sellers that have brought suit against NAR and several other large brokerages. So you have initially in the lawsuit was Anywhere Real Estate, RE/MAX, Home Services of America, Keller Williams, and NAR were the big players. Now, Anywhere Real Estate has settled, and I'll talk about that, and RE/MAX has settled. That all happened a month ago, but I'll get into that in a little bit. What these sellers are claiming in their lawsuits is that the NAR and these other brokerages are participating in anti-competitive practices by forcing sellers into a system where they pay a commission that's split between buyers and seller agents. The plaintiffs, so these home sellers that have brought the case, think that this has led to inflated buyers' fees and costs that to the detriment of home sellers. And they're claiming buyers need to pay for their own agents. The NAR has stood very firm in their stance with protecting the system as we know it today, and have said that the current system provides transparency and market-driven pricing options for home buyers and sellers. They have remained steadfast in that stance, and I would be shocked if we see settlement from NAR. So both of these cases are violations, they're claiming violations of the Sherman Antitrust Act. And if any of you track different types of lawsuits, there are some cases that can lead to what's called treble damages. That means triple the amount of damages. And these cases, antitrust cases, can have treble damages. So the Sitzer-Burnett case, that's the Missouri case, the damages there are about $4 billion. And the Morrill case, the damages are upwards of $40 billion. So not insignificant. Again, with that Sitzer Burnett case that's just going to trial Monday, NAR is expecting a verdict by November 10th. So you've got a month-long trial with any appeals starting then the following year. So it'll be very interesting. So for a litigation, for an attorney, someone that also is a nerd, and I'm okay with that. It's a very exciting time to see what's going to happen as these things play out. There's already some fighting happening last minute. Like I said, this sometimes happens, but the plaintiffs in the Sitzer Burnett case have tried to pull some of their witnesses and not make them subject to cross-examination, which is a really important thing for a defendant to be able to cross-examine, to question that plaintiff. And so there's a lot of these final fights happening. It'll be interesting to see what shakes out by Monday. So with that, what is the impact of this case? If these plaintiffs win the case, that means the industry will most certainly be changed as we know it. Agent compensation will fundamentally change. Buyers will likely have to negotiate and pay commissions to their agents upfront. That's different than what we see today. The MLSs that we participate in will have to change the way that they do business. And defendants in these lawsuits would have those massive damages to pay. Because again, you're talking about a class action, thousands of home sellers. It's covering a range from 2015 to 2020, as well as current and future sellers. All of those sellers would be entitled to damages under these lawsuits. So big implications for the industry. Now, what NAR is saying is if these plaintiffs prevail, you are going to substantially limit the amount of buyers that can purchase real estate. So they're saying there's huge public policy reasons to continue with the system as we know it. They believe very strongly that the system as we know it is market driven, that it leads to competition amongst brokers. They again are steadfast in their stance and will probably not settle before Monday. Now, moving on to the settlement. I'm sorry, I'm probably talking way too fast. I'll try to slow it down. So Anywhere Real Estate did recently announce that they settled this litigation. Anywhere Real Estate, as you may know, is the parent company to Coldwell Banker. So this is why I wanted to talk specifically about their settlement. On September 6th, they announced a settlement, and the terms of their settlement were costs of about $83 million. And then RE/MAX, about a week later, also announced their settlement. This was for both cases. So both Sitzer Burnett and Morrill, both Anywhere and RE/MAX have settled out of that litigation. And they did so because of the high amount of damages that are being faced. Potentially, they could have seen flaws in the case and felt like there was more risk to those companies and all of the entities below them. And they just wanted to pay the cost to settle and be out of it. They might have seen something else, but the other parties have remained in the suit and have not settled. Again, that's National Association of Realtors. So your NAR, Keller Williams, Home Services have stayed in, not settled. But Anywhere did, and just last Friday, they announced the terms of the settlement. So I've been waiting to see what those terms were. We did get a dollar amount on that September 6th announcement, but they didn't give any specific terms. So now the terms of the Anywhere settlement are what could impact us as a brokerage. So the first proposal, and by the way, this settlement still is subject to court approval. So it's the terms that have been released, but they are not finalized. So first, Anywhere has agreed to an injunctive relief, and that means it stops a party from acting in a certain way. They agreed to make 3 practice changes that are consistent with the NAR rule changes agreed upon in a 2020 settlement between the National Association of Realtors and the Department of Justice. And those 3 changes are: 1, Anywhere will prohibit company-owned brokerages and their affiliated agents from claiming agent services are free. 2, anywhere will require company-owned brokerages and their affiliated agents to include the listing broker's offer of compensation for prospective buyer's agents as soon as possible in each listing. And that's consistent with local MLS rules or capabilities of third-party websites. And 3, anywhere will prohibit company-owned brokerages and their affiliated agents from using any technology to sort listings by offers of compensation unless otherwise requested by the agent. Now, those apply. Oh, yeah, go ahead, Sarah.
It sounds like those are things that we were already doing.
Yes. So first of all, those apply to the anywhere owned companies, and we are a franchisee. So anything that they are agreeing to in a settlement is for their own companies, but they're recommending these practices to their franchisees. But Sarah, as you already stated, yes, these are practices that most MLSs have already implemented as a result of that NAR settlement with the DOJ in 2020. So really, it's no change. They're just making it a company policy now that they're going to push down to their company-owned entities. Not a significant change for us as brokerage because most MLSs have already adopted these rules. Second, Anywhere Real Estate has agreed to advise and remind their company-owned brokerages, franchisees, that's us, and affiliated agents that the company has no rule requiring offers of compensation. So that means, and this again kind of ties in with the rules already of the MLS, and that's NAR's big stance in their defense, is that we don't require you to make an offer of compensation. Your offer of compensation can be $0. We just recommend the participation. It's not, so that requirement for compensation can be a $0 on the MLS. And Anywhere is just going to reiterate that. However, they say so that they Anywhere says they continue to see the economic benefits that offers of compensation bring to both sellers and buyers, and the importance of making sure buyers and sellers have access to the professional services agents provide. So while they're not going to require that compensation, they're still backing our practice as we know it today. And third, Anywhere has agreed to several other practice changes. Notably, we have the following 3. Anywhere will not require their company-owned brokerages, franchisees, or affiliated agents to belong to the National Association of Realtors or follow the NAR Code of Ethics or Handbook. So this is a big change we've seen from the Anywhere settlement and the REMAX settlement, and a couple of other entities who, larger brokerages who are not even involved in this litigation. We're seeing a bit of a separation from the requirements to follow NAR. And that's for 2 reasons. One, because of this litigation, they're creating a little bit of separation, saying they don't have to participate and be a member of NAR. And 2, NAR has been in some other, the subject of some other challenging litigation recently, if you followed any of that, regarding some sexual harassment and allegations of hostile work environment. And so other brokerages are separating from NAR for that reason. But under this settlement, this is unrelated to those other allegations. They're stating you do not have to be a member of NAR. However, be aware that this is separate from the rules your local MLS may have, which may still require membership. So Anywhere is not going to require it, but your local MLS might still require it. The second practice change here that Anywhere has agreed to is that they will require their company-owned brokerages, that's Coldwell Banker Realty in our world, to clearly disclose to clients that commissions are not set by law and are fully negotiable. So this is a change that we'll probably start to see industry-wide, just being more upfront with the consumers and particularly the buyers and sellers about what is negotiable. So buyers can negotiate commissions, sellers can negotiate that. We have to make it clear that those commissions are not set by law. That's kind of straight from that Sherman Antitrust Act. And then the last practice change that I'll note here is that they are going to eliminate any minimum client commission requirements that the company-owned brokerages may have. So the Coldwell Banker Realty, if they have any minimum commission requirements, they will eliminate that. And again, that's something I do think that we'll see recommended down the chain as well. And then the last agreement in their settlement is that they've agreed to develop training materials for company-owned brokerages, franchisees, affiliated agents that support all these practice changes. So I expect this will be forthcoming. Overall, Anywhere has stated that the reason that they've settled this is to get a release for their owned brokerages operations, their agents, the franchisees, and all affiliated agents. That was their priority. That's why they agreed to settle, but they still believe wholeheartedly in that it's in the economic best interest of both buyers and sellers to work with experienced, trusted advisors. I'm quoting the CEO and president of Anywhere Brands here. She said, "We strongly believe in sellers making offers of compensation to buyers' agents to bring more eligible buyers to a listing, which increases the likelihood of a successful transaction." So with that, that's the summary, a lot of stuff, but I wanted to end on that point, talking about making those offers and talking to your sellers about how important it is to make that offer, because next week we'll have part 2 coming to our Focus Friday series on this subject, which will be Jeff Renovier will be talking to us and another managing director about how to overcome some of these seller objections, how to talk through it in a potential change in our industry, the importance of working with buyers, getting buyer brokerage agreements signed. That'll be the subject of our next week's Focus Friday. But today I wanted you to have the background, know what we're dealing with the litigation since that lawsuit starts Monday, and tell you where things sit from an Anywhere side. So I will touch base and see if there's any questions. I see a lot of questions that come through. Anything that you need me to address, Sarah?
Well, I'm just looking at Jimmy's here. If the plaintiffs prevail, the buyer's compensation is paid by the buyers. Can a buyer still negotiate the payment of a buyer's agent in a buy-sell contract?
That's a great question, Jimmy. So that's going to depend on your local rules. Some rules, state rules do not allow you to negotiate commission within that purchase agreement. So there's a lot of things that will be impacted here with a buyer trying to negotiate commission. You can always use a broker-to-broker compensation agreement. So if a seller's not offering compensation to a buyer's agent, you can still present that, hey, this buyer's interested, we want 3% commission. Always present it there. Double check with your local rules to see if commission can be included in a purchase agreement. Here in Iowa, you cannot have commission included in a purchase agreement, so you got to be careful with that. And the other issue that we're seeing that this whole lawsuit will impact is from a financing perspective, because if the plaintiffs prevail and buyers are going to have to pay their commission, then mortgage lenders are going to have to start figuring out how to add commissions into their overall financing. And that's something that some lenders are doing. We've worked through that before. We have flat fee brokers in all of our markets. So this is not a new, this is not new for most of us. We've had to negotiate commissions for our buyers when a seller's not offering it. Some lenders can add that into their mortgage. Others get wide-eyed and have no idea what you're talking about. So there's going to be a lot of training depending on the outcome of this in the mortgage industry as well.
Casey, how soon will we start to see the effects of this? will it take a few months for things to, I mean, they haven't even finalized it. These are just the terms, right? So is it possible that this will be a 2024?
Oh, yeah, most certainly, these are gonna be 2024 changes that we'll see come down, because like you said, the anywhere settlements proposed, we probably won't see that finalized. I mean, maybe by the end of the year we will, but if the judge has any changes or if there's any more back and forth on the settlement, then that will take time. Plus, most settlements also include a time period for implementation. So I wouldn't be surprised if we're looking at by 12/31/2024
Okay.
for these changes to be implemented. And again, I see Jen's question about getting commissions approved by CBDP. The rules in the proposed settlement are what Anywhere has agreed to with regard to the minimum commissions. That's for their company-owned brokerages. We've not changed any policies at CBDP, but it's something that we're watching these lawsuits closely and we'll have to review and adjust accordingly.
All right. Any other questions? Let's see them now. Otherwise, Casey, I think this is where you get to give a shameless plug for something you're going to be hosting on another spooky day of Halloween. So on
I know, what's up with this? I get the two spookiest days of the month. So Friday the 13th and Halloween day, October 31st, I am hosting a spooky legal cases class. It's at 10 o'clock Central Time. And this is one of my most favorite classes in Iowa. Some of my Iowa agents have, the past couple of years, I've done a Halloween themed class and I try to pull some spooky things. I have a lot of fun with it. It's not just fun and entertaining legal cases, which I promise you, there can be some exciting legal cases. They're not all just boring. I try to make the law seem fun, but they're also very relevant to your business every single day. So tune in October 31st, spooky legal cases. It should be fun. If you're in costume, even better.
Oh, I love it. Will you be in costume,
I
Casey?
don't know. Thought about it. I
Okay.
might have to do something. We'd be a surprise.
All right. Also, we have a lot of stuff coming up. Here next week is Gen Blue, and then please join us next week when we take what Casey shared with us today, and we're going to have Jeff and another MD help us agents understand how to overcome possible objections, or when we get questioned about it, so we know how to answer. So besides that, on October 24th is one of our first, The Power of One More. It's the agent panel. That's going to be 9 a.m. Mountain Time, 10 a.m. Central Standard Time. So that's coming up too. And then, of course, we'll be starting our business planning, which is going to take the place of Focus Fridays. And so super excited for that. I believe that's all, Casey. Our poll has ended up that it is 58% say no, they are not superstitious, and only 42% of the people who joined us today are superstitious. Whatever you are, I hope you guys have a great 13th, a great Friday, a wonderful weekend. Sell some stuff this weekend to get one more transaction in this year if you're going along with our contest. So with that, I'm going to sign off. Everyone